those 14 days, the sheriff comes back and executes the warrant. And at that point, the tenant has to be out. So let's move forward to the next slide. We're going to talk a little bit more about non-payment evictions. All right, as I mentioned before, in a non-payment eviction, the first step is going to be the landlord is going to file, or I'm sorry, the landlord is going to serve a notice to pay or quit. So the tenant has 14 days in which they can make a full payment of the rent due, and it stops the action. The landlord, if the tenant doesn't pay, files a notice of petition and serves it on the tenant. The landlord has to time that correctly. They have to serve it 10 to 17 days before court. So for example, in Glens Falls, they have evictions on Wednesday mornings. So a landlord has to know that and time it appropriately so that the potential Wednesday that they're going to hear it is going to fall within that 10 to 17 day window. That's important right now because a lot of the many of the courts aren't scheduling court appearances until after August 20th, but today is roughly 17 days before the 20th, so we might see petitions being served now. Leading up to now, the courts have allowed landlords to file the notice of petition with a court, but they couldn't serve it because if they served it before today or before yesterday, they'd be out of that 10 to 17 day window and it would then be unable to proceed. So we might see landlords filing those petitions and serving them relatively soon here. So moving forward, the court process at the initial appearance, the judge is going to hear both parties' sides. As I mentioned earlier, the HSTPA now creates a mandatory 14-day adjournment when there's an issue of law or fact, some kind of triable issue for the court to decide. It's important to note that the tenant has to request that adjournment, but if they do and there is an issue for the court to decide, the courts have to grant it. When they come back, there'll be a hearing or trial, and win or lose, the court will either issue the warrant or not, and then execute the warrant. So that, in a nutshell, is the non-payment process. There's a lot of other information, but we're just kind of doing a quick hit here today. So why don't we move forward? So one thing I want to talk about here is the status of the proceedings. The case isn't really started until the notice of petition and petition are filed and served. After that point, when there's a court date, it'd be considered a pending matter. So we can move forward on the slides. So it would be pending until the point that the judge makes a decision. After that decision, if the court issues a warrant, it would then be in enforcement status. So anytime after the warrant issues, if it's going to the sheriff, if the sheriff serves it and you're within the 14-day period, it's in the enforcement status. So this might come into play a little bit later. It was important during the moratorium because cases were addressed differently depending on where they were in the process. One thing I'd like to note here is that the initial notice to pay or quit is a 14-day notice, and the warrant of eviction at the end is also a 14-day notice. So if you're talking to somebody that has an eviction matter and they say, I received a 14-day notice, it's very important to figure out which of those notices it is. If it's the notice at the very beginning to pay or quit, there's a lot of things that could be done. If it's at the end of the case, if the decision's already been decided, there are going to be less options for figuring out a positive resolution to that case. So I just want to note that they're both 14-day notices, and if you're just talking to someone, they might not convey to you which of those notices it is. So moving forward, we have a a chart here just about the changes that the HSTPA has made to the timelines. It's really quite considerable. In the past, the notice to pay or quit was only 3 days, and as we've discussed, now it's 14. The notice of petition used to be served 5 to 12 days before court. Now it's 10 to 17. Previously, the adjournment wasn't mandatory. Sometimes you'd get it, sometimes you wouldn't. Sometimes the court would decide the matter right then and there. And the warrant at the end was also a 72-hour notice, not a 14-day notice. So if you look at this, if the process went as quickly as possible, which never happened, but it could have been roughly 8 to 17 days between the service of the initial notice until the tenant actually had to be out. Now we have 14 days, 10 to 17, a mandatory 14-day adjournment, and a 14-day warrant. So that's 52 days minimum. So that's really quite a considerable change. And it gives people more time to try to make alternate housing plans. So moving forward, we're going to discuss the holdover evictions. So as I mentioned earlier, there are 3 main types that will pop up. There's actually a great number of them, but the termination of the month-to-month tenancy is the kind of case that we hate to see, because generally there's not much that can be done to stop the termination of a month-to-month tenancy. The idea is that you have a freedom to reach an agreement, to rent a place. Both parties can terminate it at any time at will. In the past, before the HSTPA, it was a full calendar month's notice. Now the notice depends on how long you've resided there, or if you have a lease and the term of the lease. So here I have a notice of termination with a 30, 60, 90. So it's 30 days if you've been there less than a year. It's 60 days notice if you have a year lease or you've been there longer than a year. And if you've been there longer than 2 years or have a 2-year lease, it's a 90-day notice. So again, this provides tenants more time to make alternate housing plans. The process is generally very similar to the non-payment case, other than the notice periods. Landlord can file the notice of petition and petition at the time that the notice period has run out. And moving forward, we'll see that there's court, there's an adjournment, a hearing, and if the tenant loses, a warrant will be issued. It's important to note here on the adjournment that the adjournment is only granted when there's an issue of fact or law to be decided by the court. So in non-payment cases, there often is some discrepancy in the amount that's owed or payments that were made. But I'll say again that the termination of the month-to-month tenancy, if the landlord serves the notices correctly, there might not be an issue of fact or law to be argued over or decided by the court. So it's possible a court won't grant that 14-day adjournment in cases where there's no issue to be decided. So that could happen in a termination of a month-to-month tenancy. All right, now we're ready to move forward. So as we discussed earlier, if the landlord intends to raise the rent by 5% or more, or if they intend to terminate the tenancy, then they have to provide certain notice. It's the 30, 60, 90 rule. And if we could move the slide forward. And you could continue and reveal the entire slide. So this is just what we talked about. It's the notice period and the time frames, depending on how long a tenant has resided there. All right. And it's important to note a couple things, that the 30, 60, 90 rule doesn't apply to non-payment cases. Again, that's just a 14-day notice. A lot of times tenants might think that they have 30 days no matter what to vacate, and that's just not true. In the non-payment cases, as we saw, there are 14-day time periods. The 30, 60, 90 rule doesn't apply to violation cases. So if the landlord has alleged that there's a violation of the lease, The 30, 60, 90 rule does not apply. Depending on the lease and whether or not it's private or subsidized housing, the landlord might have to serve a notice to cure, which gives the tenant an opportunity to fix the problem. But they don't have to necessarily unless it's required by law or lease. And it's important to note that on the tenant side, they only have to provide, I believe it's 1 month or 30 days notice to the landlord if they want to terminate the tenancy. All right, so one of the holdover terminations we discussed was a termination for a violation of the lease. As we discussed, a notice cure is not necessarily required, but we can move this slide forward. And I think we could reveal the entire slide. So this process is very similar. There's an important thing to note is that at the end of the case, if a judge finds that there has been a violation of the lease, one of the new laws that came out with the HSTPA is that it allows a court to grant a 30-day stay after the hearing, after the decision that there's a violation, to cure the problem. If the problem is cured, then the eviction stops. So we can move forward one slide and we're going to discuss this a little bit more. So it's a little bit interesting that this is a stay that's granted only after the court has made a decision that there is actually a violation. It would seem to make more sense maybe to have that 30-day period to cure before they go to court and provide all their evidence and the court makes a decision on whether or not there's a violation. But the legislature has done it this way. The 30-day stay is after the court decides there is a violation. It might be good in that it conveys to the tenant that they're actually going to be evicted if these problems aren't cured. So they might take it more seriously. I don't know if that's the intent behind it, but that is how this works. I've heard in other jurisdictions that the most likely thing to happen is at the end of a hearing when the judge decides there's a violation, they'll likely put off a date for 30 days to have the parties come back and discuss whether or not the violations were cured or not. So it sounds like it is likely working out pretty well. So let's move forward. And I haven't been tracking the time. I know we want to keep to a tight schedule. How long do you think we have left?
We have 35 minutes left.
Okay. So again, we've been talking about the Housing Stability and Tenant Protection Act quite a bit. I'm just going to make a few notes here, and we're likely to buzz through this, but all this information is going to be here, and we've got an informational flyer with some of the highlights of this law as well that will be in the materials. So we can move forward to the next slide. The HSTPA is notable that it's probably provided the strongest protections for tenants that we've had in the state. So here are a couple notes. One of the important ones is that the tenant can make a payment of the full amount of rent due basically any time in the process. In fact, they're allowed to make the payment even possibly after the sheriff comes and executes the warrant. It's got to be pretty quick afterwards, but anytime in that warrant period, even after the court has decided that the eviction is going to go forward, they could still make a full payment of everything due. And even if the landlord refuses it at that point, because they've already gone to court, they've won the case, they probably want the tenant to move out. The tenant can take the money to the court and deposit it with the court, and that should stop the eviction. So it's just important to note that the full payment will stop the eviction. It's probably also important to note that a promise to pay or an agreement to pay from an agency is not likely to be enough to stop an eviction. It's got to be funds that are either deposited with a court or paid to the landlord. A couple other important notes. A landlord is not allowed to collect attorney's fees on a default judgment. The HSTPA has also affected how security deposits are handled. It used to be that landlords had an indefinite amount of time to return a security deposit. Now they have 14 days to either return the security deposit or provide a letter that justifies why they're keeping all or a portion of it. The HSTPA also provides for walkthroughs and assessments of the apartment, both before renting and at the time that a tenant is about to vacate. The tenant does have to request the walkthrough, but the landlord has to provide it, and they could take notes, and anything that's not raised during the walkthroughs can later be brought up in court to prove that those weren't issues that existed at the walkthrough. Now, one of my favorite new portions of the law is that if a landlord unlawfully locks out a tenant, it is now a criminal misdemeanor. And that's big because in the past, when there's been an unlawful lockout, often the first move is for a tenant to contact law enforcement, sheriff, local police, and sometimes they're very helpful. And other times, if they don't want to get involved, they'll say, well, it's a civil matter. It's not a criminal matter. So you're going to have to fight that issue in civil court. We can't be responsible for civil matters. Now it's a Class A misdemeanor. It is literally a criminal matter, not just a civil matter, and they should address it. However, there's probably great reluctance here for law enforcement to get involved in these cases, especially where landlords and tenants have arguments on both sides. Law enforcement will feel like they're in the middle and they're doing the job of a judge in a civil case. So we've noticed that law enforcement is still reluctant to get involved in these situations. We thought this might have critical application now during the pandemic when landlords may be facing mounting frustration at not being able to use the lawful eviction process to evict a tenant. And we have had a number of calls for different lockout scenarios. Most of them have resolved one way or another. And importantly, the New York State Attorney General, understanding that law enforcement may be unlikely or reluctant to get involved, has also written a letter informing all the law enforcement offices and district attorneys' offices of this law and encouraging them to enforce it. So this letter is also going to be in the materials. I'm happy to share it with anybody. If you run into a situation where a tenant has an unlawful lockout, feel free to provide this letter to the law enforcement if you communicate with them, because this is supported by the state. It should be enforced, but we're still having some difficulties convincing law enforcement to get involved in these situations. Moving forward, we're going to talk about the moratorium. Now, as we talked about earlier, the sources for the moratoriums have come from various places. We've got the executive orders from the governor. We've had administrative orders from the courts. There was the Federal CARES Act, which was federal legislation. And we've now got the New York Tenant Safe Harbor Act, which is state law. So I'm not going to spend too much time on this because it's kind of more historical information at this point. But if we could stay on this slide for a moment, the governor issued a moratorium basically saying there shall be no enforcement of an eviction of any tenant for a period of 90 days. And this was issued on March 20th. So this postponed all evictions through June 20th. Now, we talked earlier about the status of cases. This executive order applied only to enforcement of evictions. So as we discussed earlier, the enforcement stage is at the end after the court issues a decision. It's not, this executive order does not prevent a landlord from filing an eviction or proceeding on eviction. It just prevents the enforcement. So it became apparent that the governor's office really meant to stop all evictions at every stage of the process. They only focused on enforcement in this one. They later issued another executive order, 202.28, where they then included initiation of proceeding. So they prohibited landlords from starting eviction actions as well. But 202.28 was a little bit controversial because it said that there shall be no initiation of a proceeding for non-payment of rent if it's owned or rented by someone that is eligible for benefits or otherwise facing financial hardship due to COVID. So as we learned earlier, there are two types of evictions, non-payments and holdovers. This one, which was issued and extended the moratorium from June 20th to August 20th, only applied to non-payment cases by the language in the executive order. It didn't apply to holdovers. So that meant that, according to the executive order, landlords could proceed on holdover evictions after June 20th. However, the governor's office, through back channels, indicated that they had intended to stop all evictions, even though that is clearly not what the executive order said. So what happened was the administrative orders filled in a little bit, and the courts even filled in a little bit. So they've essentially extended the moratorium by saying that you could file these actions, the allowable actions, between June 20th and August 20th, but that they wouldn't be scheduling any hearings or appearances until after August 20th. So I'm jumping ahead a little bit when I mentioned those administrative orders, but here we have a more recent executive order from July. It essentially says the Tenant Safe Harbor Act is taking over on the moratorium side. So that was a New York state law passed the 30th of July. And so this executive order basically says, we're going to let that state law take over on the moratorium from here. So if we could move forward. So now just a quick note on the administrative orders. The administrative orders came out through the courts, and basically they said, we're not going to allow any non-essential functions of the court until further notice. So that was an open deadline. And they defined essential and non-essential matters, and evictions were not essential matters, so that they were prohibited until further notice. Importantly, one of the other things that came out of the administrative orders is they said that there shall be no issuance of a warrant if the tenant defaults in their appearance. So if they don't show up to defend themselves in court, the courts can't issue the warrant. So they don't want people afraid to appear publicly because of fears of the coronavirus, and as a result, getting evicted. So we could move forward through this. We already touched base on these things. Oh, I'm sorry. If you could go back to that last one, there was an administrative order issued for the 4th Judicial District, which covers the area that we're in. And basically it said, we're gonna stay all the evictions, just like the governor said in his executive order. But as we discussed, the wording of the governor's executive order was a little bit controversial. It said one thing, the governor's office said it included both non-payment and holdover, but it just said it prohibited non-payments from moving forward. So now an administrative order came out that said, we're saying what the governor said, which was a little bit of a problem because people were unclear what the governor had said. So as I mentioned earlier, the courts kind of filled in the gaps here by saying we're not going to have any appearances scheduled until after August 20th, and that kind of closed the controversy. All right, moving forward. Now, there was an administrative order that required landlords that were filing evictions to include an affidavit or an attorney's affirmation, which basically said, we're aware of all the COVID-related laws and the moratoriums, and these pleadings are consistent with those laws. So that's important because the executive orders didn't allow non-payment cases to move forward if there was a financial hardship. So if a landlord filed an eviction action in a non-payment case, knowing that there was financial hardship, the tenants could raise that as a defense, or the court could look into that on their own and stop the non-payment eviction from moving forward. So a quick note on the Federal CARES Act. This was in effect from March 27th to July 24th. This applied to subsidized housing programs and basically any property that was backed by federal funding or certain types of federal funding. And it mainly applied to non-payment evictions. So what it said was, and if we could move forward to the next slide, what it said was that you can't evict for non-payment during this time. You could send reminder notices that they're late on the rent, but you can't send a notice to vacate until after July 24th. So we're already past July 24th, but the part of this that continues is that there has to be a 30-day notice after July 24th. So that bumps us out to August 24th. So even if there's a non-payment in a subsidized or otherwise covered property, the landlord has to serve a 30-day notice, which couldn't have been served till July 24th. So landlords won't be able to file petitions until after August 24th. So we've got a little bit more time for those tenants. So now let's get to the New York State Tenant Safe Harbor Act. So this is where we are now. The courts are prohibited from issuing a warrant of eviction or judgment of possession for non-payment of rent if it occurred during a certain period. Now, that period starts on 3/7, according to the law, March 7th. So that means that it probably doesn't cover March rent. If March wasn't paid, because that was before all the restrictions went into place, then they could still be evicted in a non-payment case. If their rent was due possibly on March 15th, in other words, if a tenant had an agreement that rent was due on the 15th of each month, then that rent payment would be covered. So what we're essentially looking at here is rent from April forward. And I'm sorry, if you could go back to that slide. So as we just talked about, this time period starts on March 7th. So the question is, when does this period end? We're still in the period. The law states that this period continues until the date on which none of the provisions that closed or otherwise restricted public or private businesses or places of public accommodation, or required postponement or canceling of all non-essential gatherings of individuals of any size for any reason in any past executive order, and as further extended by any future executive order issued in response to COVID in the county of the tenant's or lawful occupant's residence. So basically, right now, the executive orders have stopped restaurants, concerts, public gatherings. As long as those executive orders are still in effect, then we're still in this time period that's protected. So basically, until the protections and the restrictions for the pandemic close, we're going to be in this period of non-payment. I'm sorry, we're going to be in this period where non-payment evictions can't be granted. So again, just to kind of summarize that, if you have a non-payment case and you've suffered a financial hardship, if your non-payment is between March 7th and some future date when there are no more restrictions, then you can't be evicted. The court can't issue a warrant of eviction or a judgment of possession. They can grant a money judgment for the amount that's due, but they can't evict you. Now, the problems are going to be if there was non-payment before March 7th. So if February hadn't been paid, if March was due on the 1st and hadn't been paid, then you likely can still be evicted. And it raises an interesting question. If March was the only month that wasn't covered and wasn't paid, and if you pay it now, everything else that wasn't paid would be in the protected period. So can you now just pay March and be covered and protected? I don't know the answer to that, but I think it's probably worth a shot. All right. I see a question. I'm going to be glad to answer it. I'm just going to move through the rest of this. I think we're sort of near the end of the presentation. As we discussed, courts can issue money judgments. And as we discussed, a tenant can raise a financial hardship. So the Tenant Safe Harbor Act includes a list of factors in considering whether or not a financial hardship exists. And I think this might answer your question. So what would happen is the landlord would file, there'd be a court date, and at that court date or court appearance, you would raise the issues that prove there was financial hardship. And one of the things they're going to look at is your income before and after the pandemic and the covered period. So if you were rendered unemployed by the pandemic, but you were making more money afterwards, you might not have had a financial hardship. But if you lost your work and for some reason you weren't able to get unemployment, or if unemployment was less than what you were making, you might be able to argue that you had a financial hardship. So I think it's going to be a very fact-based inquiry. I think a tenant is going to have to raise the issues that they think that they've faced that created the financial hardship in court, backed up by as much evidence as possible, whether it's pay stubs, bank statements. If they have a statement from their job that says that they were laid off, those types of things are going to help them prove that they faced a financial hardship. All right, let's move forward. So we've talked about a lot of different things. So where are we now? As we discussed earlier, we're likely to start seeing eviction petitions served on tenants very soon. It could be today. Petitions can be filed now in holdover matters and non-payment cases. The non-payment cases that can move forward to to a warrant of eviction would be ones where there's non-payment for time periods that aren't covered by the covered period. But a landlord might not know that, or might file the non-payment eviction anyway and just see how they do. So we're likely to see these go to court, and then we're going to have to see how the courts decide them. If you're working with a tenant that faces a non-payment eviction, like we just discussed, you're going to want to coach them to bring as much documentation as possible that shows that they've faced a financial hardship. And I also want to note that the courts are trying to clear their dockets as much as possible right now before they're hearing cases and deciding cases. So they're sending out notices, offering settlement conferences between the parties, hoping that the parties are going to reach agreement, settle the case, and move it off of their docket. Now, I've seen one of these notices. It's not entirely clear that these are voluntary. So if you have somebody that receives a notice to be in court for a time period that's before August 20th, you want to see if it's a settlement conference, because the settlement conferences are all voluntary. They don't have to appear. They can decline. They could write a letter and indicate that they're declining. If they don't show up, they won't be evicted. If it's just a settlement conference, it's not mandatory. If it's a court appearance based on a petition, then they should definitely show up and or contact the court and figure out how to appear either in person or possibly virtually, if that's possible. So we have a couple more notes. We discussed the Tenant Safe Harbor Act. We discussed non-payment cases. We discussed the CARES Act. And basically that's it. So yes, I want to thank everybody for being here. And I see that we have a couple questions. I'm going to take a look at those and see if I can answer any of them.
We had a follow-up on the question about hardship. If the additional 600 in unemployment and couldn't return to work yet, would that make the hardship null and void?
I mean, it's about financial hardship. So I think you'd have to look at what their income was before the period and after the period. If the unemployment and the additional 600 meant that you were making more afterwards, you'd have a tougher time proving that it was a financial hardship. Now, there might be other costs. You might have childcare costs because the schools aren't open, childcare centers might not be operating. So you might have other issues that have caused financial hardship. So it's really gonna depend on the specific situation of the person. You might still be able to argue for it, but you're gonna have to show essentially a net loss of income. I would think.
And we had one other question that says, does COVID have an effect on abandonment cases with apartments/tenants?
I'm not sure I understand the question. So
This is Matthew. Can you hear me?
Yep.
yeah,
Perfect. So that was my question. Thanks for taking the time. We had
Yeah.
a specific where a tenant was living in an apartment and decided to go stay with family, basically ceased all contact with the program and the landlord.
Yep.
We tried for some time to get a hold of her. Now, in the case the landlord can't file an eviction, does the standard 30-day of abandonment still hold, or is that null and void because of COVID? And I'm having trouble finding answers, actually. I've tried reaching around a bit, and I can't seem to get any clarity.
yeah, it's going to depend on a number of different facts and factors. If this is subsidized housing, they might have in their administrative plan a set of rules that they're supposed to follow if there's abandonment. If it's a private landlord, if the tenant isn't there, the landlord might take action. Some of those actions might result in the tenant having a private cause of action for damages. In other words, if the landlord removed or destroyed the possessions, then the tenant might be able to sue the landlord for damages. But I don't think, other than the moratoriums we described, the COVID-19 moratoriums would have any effect on that situation. The only way it might affect it is a landlord might not have filed an eviction action, might not have been able to file an eviction. In other words, if I was advising a landlord that had a tenant abandon the property, under normal circumstances, I'd tell them file the eviction and get the warrant, and then you can take back possession of the apartment, and there's really no issue. The tenant can't raise any issues with that because they had an opportunity to go to court and address it. During this time, when there is no access to the courts, it's possible a landlord might not go through that process to be safe because they can't. So I guess I don't want to get too bogged down in one specific case. If your particular client has questions, feel free to give her our number. We'd be glad to talk to her and see if there's anything we could do to help her. But ultimately, I'd say no, there's not going to be too much effect on abandonment issues.
Okay. Thank you very much. I appreciate it.
You got it.
Stuart, I had one question. I just wanted you to clarify for me, for everybody, the 30-day notice. It's always, I've been to court with a few people for eviction, and it was said to me by the judge that giving the notice on the first of the month, technically we shouldn't. We're responsible for that month and the following month. I got the message that if you didn't give the notice before the first, you're obligated not only for the entire month, but the following month as well, because it has to be. The tenant
is obligated, or the landlord's obligated?
The tenant.
Well, the previous laws before the HSTPA allowed termination of the month-to-month tenancy with one full calendar month's notice. Okay. So oftentimes you'd have situations where if it was served on the 2nd or 3rd, you couldn't say 30 days till the 2nd of the next month because that wasn't a calendar month. So once you got to the 2nd, you already missed that calendar month's time frame. The new law under the HSTPA allows a landlord to provide 30, 60, or 90 days notice. So we're no longer looking at that full calendar month and that situation. So now it could run from, I think, the 2nd to the 2nd of the month.
Okay.
I believe the same is going to be for the tenant as well. I don't know what that means as far as rental payment obligation, if they're going 2 days into the next month, if it's going to be a full month's rent or prorated 2 days worth of rent. It's probably worth picking your date so you're out at the end of a month.
Makes sense. Well, thank you very much, Stuart. Is there any other questions? Does anybody have something they think they can add to this discussion? I know that some of this was billed about possible resources to help mitigate evictions. I know presently we are, our counties are looking to apply for ESG funds. I actually have a call in about 5 minutes after I get off this call to listen to OTDA talk about that. Within those funds may be some resources to help with paying arrears. Has a whole lot of caveats, a whole lot of discussion of you have to exhaust other existing resources before applying for this. But there might be an opportunity. It obviously, just like Stuart was explaining, it's a case-by-case type of thing, but know that there may be an option in that regard. Hopefully folks who are looking for assistance saw the earlier emails on the HCR funds that were out there to help with some arrears. That deadline is passed, but who knows? We have the powers that be arguing amongst themselves about another CARES Act. There may be more resources coming down the pike, and you can be sure that as CARES and the COC become aware of these resources, we will definitely push it out so that people know what exists, so that, you know, heaven forbid you have an issue that needs these resources, we'll at least let you know how to start the process. All right, got a quick comment question. I saw that Andy from Captain is on. Are there still step funds to assist with security and first month's assistance? Would you care to answer that, Andy?
Yes, simple answer, yes, there is. So with much of the same thing Stuart's talking about and the things with COVID-19, we haven't had a lot of requests for that funding just yet. So yes, that money is still available, both rapid rehousing and prevention dollars. So anybody who is truly homeless, needs help getting in with first month, last month, and maybe the first month of rental assistance, that's definitely qualifies. Or if somebody is facing, you know, housing instability because of an eviction or other proceeding, prevention dollars are available. So just for clarity, Captain takes care of Saratoga and Wade House takes care of Warren, Washington. So if you have a case Warren, Washington, suggest you reach out to Wade House and Annette Pliniak, their program manager for that, or Jessica Valsic for us.
Thank you.
Yeah.
Well, we're coming to a close. Are there any other comments, suggestions? It's a lot of information, and thank you very much, Stuart.
You're welcome. I hope it was clear and not too boring.
Well, I can't promise you on the boring part. It's kind of dry material, but it was very clear. It's not a you thing. That's more of a, but it's important information, and I think everybody gets some value from it.
Good. Yeah, I'll just say, I'll put in a quick note. If somebody is working with somebody that has a eviction action, legal aid is open. We're operating. Probably the earlier they get to us, the better, because we might be able to negotiate something or point them in the direction of funds that might be available as they become available. So
Yeah,
make that
for
note.
those writing the application for the ESG funds, keep Stuart's Legal Aid Society in mind. If you're looking to contract out, it might be a resource. I know other counties and groups that are doing it. According to Maggie, are putting in their local legal aid society as part of that.
Appreciate that.
Sean, I just wanted to provide an update on the city's funds for prevention and rapid rehousing. The council will be voting on the program guidelines that I've drafted tonight. I presume they will be passed, and after that, you'll have some more information for me. I'll be hosting at least one informational session with our nonprofits who would like to participate as a participating provider to access those funds on behalf of their clients.
Terrific. Thank you very much. And I guess with that, I want to thank everybody. We're coming up to the 1 o'clock hour. Some of us got to get off this and get right into another meeting with OTDA. And Andy's nodding his head. Yes, we got to do that. So thank you, everybody. Appreciate your time. This recording will be available on the CARES website sometime in the near future. You can tell all your friends who missed it to tune in, and if they're looking for information. Perhaps we could also upload a copy of the slideshow.
Yes, I can do that.
With that way we don't have to throw it out in an email. We can find, I can forward it in an email, but we can also have it available right there with the video.
Yep,
So
I can do
people
that
can
for you.
download
Not a
it.
problem.
Okay, that's great.
Thanks a lot, everybody. Thanks, Stuart.
All right, thanks,
Okay.
guys.
Take care.
Thank you.
Bye.